All right. Good afternoon, everybody. My name is Josh Bryant. I'm the managing attorney at Church General Counsel. You can learn more about Church General Counsel online at churchgeneralcounsel.com. Find us on Facebook. Find us on Twitter. Twitter handle is Churches Lawyer. That's plural churches. Churches Lawyer. You can see updates there. You'll see some case updates as I see them. Some quick tips, things like that you can pay attention to and help your church out. And that's why we exist. I want to give you just a quick background of what we do. First of all, just some housekeeping items real quick. Down at the bottom of the screen, you'll see a button that says chat. If at any time during the course of our webinar today you've got a question, certainly feel free to throw that in the chat. There's also going to be a means there by which you can raise your virtual hand. Feel free to do that. I'd be more than happy to unmute you. If you want to turn on your webcam, you can do that as well. Ask any question that you've got. This is designed to be somewhat interactive, and so I'd love to hear any questions you've got, any comments you've got. If you've had similar situations in your church or in your ministries, would love to hear those and see how we can take the cases that we're going to talk about today and apply them to specific situations, because the whole idea is that we want to do everything we can to keep our churches out of court. We're going to see some situations today where churches are in court, and it's just not good. So we want to help you mitigate risk, manage that risk, and do so in a manner that helps you free up from the administrative burdens of running a church and move into a season of ministry where you can actually do ministry without worrying about paperwork. So all that said, this will also be recorded. It will be available for your review later, and we'll talk about how you can get access to that a bit later. But let me give you just a little bit of my background, because I don't see any familiar faces in the group today. There may be a couple of you there, but let me give you just a quick background of who I am. As I said, my name is Josh Bryant. I live in Northwest Arkansas. I went to the University of Arkansas School of Law, finished there. I actually just had my 10-year reunion. And so finished in 2008, took the bar, passed the bar exam. God saw fit within a month of me being an attorney to call me into ministry, and I yelled and screamed for a while saying, "Why did you send me to law school only to send me to seminary?" But I did what he told me to do, even if it took me a few years. I practiced for 5 years doing litigation work, small businesses, family, criminal, just about anything that walked through the door that I needed to take. Did some litigation, but also started seminary and went through seminary while also being in law school for at least a little while. Being a lawyer for at least a little while. And then got to a point to where I wrapped up my law practice and sold it and started in ministry. Did that for about 5 years as a discipleship pastor. But the minute I stepped on staff, realized I was getting question after question after question from churches all over the state, and started becoming some churches all over the country as well, calling and just asking a few questions and saying, we need some help on this particular issue. And so it started to dawn on me finally why God sent me to both seminary and law school. And I tell people God didn't call me out of ministry. He just moved me into a new season. And so that's what we're doing here at Church General Counsel. We are here to minister to the church, to come alongside churches and help them with their risk management, their legal compliance, but also anything else that comes up that would help them facilitate their own church growth and things like that. So that's why we're here. So let's just jump right in. We're going to go right into some cases here. These are all cases that were reported by either state appellate courts, state Supreme Courts. Of course, there haven't been any major Supreme Court cases last month that had religious liberty implications or implications on the church, but certainly some cases out of the various circuit courts of appeal and some federal district courts interpreting that law as applied to specific cases. I read about 27 cases. We're going to talk about 3 or 4 of them today, depending on time. I want to be wrapped up by about 3:30, obviously opening up for any questions that come up as well. So I want to finish my part by 3:30 and then any questions afterwards. But again, if you have questions in the meantime, feel free to throw them in that chat window. I'll see those. Or use the virtual raise my hand button down there at the bottom, and we will certainly do what we can to answer any questions you've got. So we're going to jump right in. The first case we're going to talk about is Hopkins versus St. Agnes Church. It's a case out of the state of New York. And this is really a pretty common case It had a little bit of nuance to it, but it's a basic slip and fall case, but it gives some great examples as to how we can protect our churches and some things that we can do to make sure these don't happen. And so, again, basic fact pattern, the plaintiff here was walking down the steps of the church, slipped and fell, and they sued the church. And there were really two different types of issues. They're very similar, very related, but two things we're going to talk through. Number one was just a basic slip and fall negligence claim. This can happen anywhere. It can happen at the local grocery store. It can happen, going to your lawyer's office, I guess. So these basic slip and fall negligence cases can certainly happen at church. It does happen at church. But then the other one that it raised was a property defect case that caused injury. And so the argument was that there was a defect to the church property that caused an injury, and so the plaintiff felt it was necessary for the church to be liable for that injury because of this defect in the property. And the specific defect was that the steps were unequal in height going down this outdoor staircase, and so because of the unequal height, the argument was that that was unsafe. The church should have fixed that, and because they didn't, the plaintiff felt like the church was liable. Now, in this particular case, the court disagreed with the plaintiff, and the church won that case. But let's talk about that just for a little bit, though. So here's the legal principle we need to understand, is that either way, either in a negligence claim or in this property defect claim, it's really just a restatement of basic negligence, okay? And so there are four elements to a negligence claim. Number one is a duty. All right, so what duty do you owe to your congregants? What responsibility do you owe them? The second is a breach, and that's simple. You didn't fulfill your duty, didn't fulfill your responsibility. That's the breach element. The third element is the plaintiff has to prove that there were damages. Okay, so what damage was suffered? Did you injure yourself? Did you have medical bills? Were you out of work for a few days or weeks? And then finally, the plaintiff has to prove cause, and that means that the defendant or the church caused the damages that occurred either by some act or some omission of some sort. So let's jump into that on this theory of basic negligence, okay? So basic slip and fall negligence. What's your duty here? All right, well, a church has a duty to keep floors, walkways, sidewalks, those things need to be reasonably clear of debris, clutter, liquids, slippery substances, and so forth that could cause somebody to fall down, to slip, to hurt themselves, okay? And so you've got a duty to do that. Now, how do you fulfill that? And ultimately, this is where a lot of this conversation needs to take place is, okay, based on the fact that we do have people coming into the church, we've got people we're inviting, we've got vendors that we're giving a license to be there and, work on the electricity or whatever, based on the fact that sometimes even churches have trespassers. What is our duty to all those different people? We're going to talk about those over the next few minutes. So first of all, how do you fulfill that duty? There's two scenarios that I can imagine off the top of my head, and I think this is probably what happened in this case. The court didn't specifically say that those steps were slippery, but the case was reported in April, which means it was probably filed in January or February. This was all done in state court in the state of New York, so it makes me at least think that the steps may have been slippery, and that's what caused that slip and fall. So let's talk about your inclement weather policy. When do you call off church due to weather considerations, ice, sleet, snow, whatever? I live in the South where a half an inch of snow and they're shutting down everything. You can't hardly move, and that I exaggerate a little bit, but only a little bit. So depending on where you are will depend on how comfortable people are driving and walking on slippery surfaces and things like that. But in terms of your actual inclement weather policy, when do you call off church? And if you don't call off church, what are the things you do? That policy doesn't need to just help you make that decision. That policy also needs to spell out that if there are slippery sidewalks, what are we going to do about it? So, for example, what sidewalks at your church, what parking spaces and parking lots can you reasonably clear in sufficient time to get people in the building for church? Because if you're going to invite people to come to church and you're going to tell them, hey, we are having services despite the fact that it's Icepocalypse 2.0, you're going to have a duty to take certain precautions in order to make sure your sidewalks and your parking lots are reasonably clear. So how do you you do that? How do you mobilize volunteers? How do you get out there and lay salt, or get your snow shovels out, or snow plows, and get all the snow and stuff off of the roadways and the sidewalks? How do you do that at your facility in order to protect the people that you're inviting to come to church services that Sunday? What personnel are going to be available to help you do that? Can you offer valet parking of some sort, where you have people just come to the front door? We're going to make sure all the front area is completely clear, and then we'll go park your car, because we don't want you walking on slippery sidewalks and surfaces and hurting yourself. Or if you put out an announcement, say, hey, we are going to have church today. We're going to do this on Facebook, or we're going to put that out on Facebook, push it out on social media, or on your website, or over the radio, or whatever. Can you, in doing so, have a little disclaimer that says, you know what, come at your own risk, because the parking lot is slippery, so be very careful. All of those things can help mitigate some of the risk of somebody coming and slipping and falling in your inclement weather policy. Now, that only happens a few months out of the year, but it doesn't matter what time of year it is. Somebody could slip and fall on a slippery substance inside your church facilities. And so we need to talk about what a spill response plan looks like, or a hazard response plan looks like. And so there are really 5 key components of this particular policy that, when a church asks me to help them write this policy, that I ask to see. And the first one is monitoring. Is that you need to have somebody, while there are people in your building, who are monitoring the facilities, looking to see, is there coffee spilt on the stairwell? Has somebody dropped is there a cord, a microphone cord running somewhere? Is there a power cord somewhere running across the floor that somebody could trip on? You need to have people monitoring that. And the first objection I get when I tell churches that is, man, we were tapping our people out. We've got people at the doors in our guest services, welcoming people. And we've got people in the parking lot helping people get in. And we've got people in the nursery and the kids area and the student area, and people teaching small groups in Sunday school. I mean, and they're in the choir, they're musicians. We just don't have the personnel to do that. And here's what I would say: utilize your current volunteers. We're going to talk about why here in a little bit more, but if you can take the volunteers that you've already got and just train them a little bit to say, listen, if you see a spill, if you see a hazard in the facility, here's how you need to address that. Don't just let it go. I think that's a great way to implement a monitoring policy or a plan into this overall spill response or hazard response policy. So make sure you've got somebody trained to monitor your facilities and make sure that hazards are quickly addressed. And here's how we're going to do that. Number one is through notification. This is the second component of this hazard response policy. So you're going to notify somebody. Who do you notify? Well, do you notify custodial personnel? Do you notify somebody else who can go and get the necessary supplies to clean up a spill? Or do you notify, hey, this is a microphone cord, so who in the worship ministries can I call and notify, hey, we've got a hazard here that we need to deal with? So you're going to notify somebody that this needs to be taken care of. You're going to cordon that area off. That's the third part of a hazard response policy. Is we want to make sure that there is some way we can cordon off the area that's a hazard, just to keep people away from it. Okay, real simple. Get some rope, get a wet floor sign, get whatever you need. Find a way to mark that off and keep people away from that hazard. Warning people. This is the fourth policy. You need to have some way of warning them, and that kind of goes in the cordoning aspect of it as well. But you can warn people with a wet floor sign. Hey, be careful, this is slippery here. Or, hey, be careful, there's a hazard here that you need to be aware of. And finally, obviously, getting it cleaned up. You need to take reasonable steps to make sure that those hazards are addressed and cleaned up as quickly as possible, and then making sure that the area is safe before allowing people to walk back through there or come through the area and subject themselves to the possible risk of getting hurt. So that's how I would go about fulfilling that duty, is just talk through this hazard response policy and an inclement weather policy, making sure that you know how to properly address those particular concerns. Now, when have you breached that duty? What are some things that you can do to breach that duty? And really, that's a very case-by-case situation. In this case, it wasn't reported, but let's say, for example, that those stairs in New York were slippery. Did they breach a duty by not laying down salt? Did they breach a duty by not scraping the ice off of there? Or did they breach a duty by not having a sign up that said, caution, this is slippery? And so it's going to be a real case-by-case scenario, but here's some questions you can ask yourself, and that I would certainly ask if a church came to me and said, hey, we're being sued. These are some questions I would have. Number one, who knew about that hazardous condition? And when did they know about it? If somebody spilt coffee and then they turned around and immediately slipped on that coffee, I'm sorry, you're probably not negligent there, because the church had no means of knowing or cleaning up that particular incident, and not to mention the fact that the person who spilt the coffee is also responsible there. So second of all, who should have known about those conditions? Because the law, as we're going to see here in a minute, talks about not only your actual knowledge, but what you should have known. So who should have known about those hazardous conditions? Did you have a volunteer or employee serving who knew or should have known about those conditions? If you've got an employee or a volunteer who's working in any capacity, those guys could result in knowledge being imputed to your church, such that you should have known about that hazard, and it should have been cleaned up such that you didn't have a problem there. So did you have somebody working? Was there a volunteer or an employee who was told about those conditions? Did a volunteer or an employee do anything to cordon off that area? Did they do any of those things that we've talked about in that policy? And if they've done those things, did they clean it up? Did they warn people about the hazardous condition? If they've done all that, then there's an argument that you've done everything you could do. All right. Just because you have a duty does not mean you breached it when somebody falls. Okay. That's what we call negligence per se. And that's not always the case. So you can still do everything right and still do everything you can to prevent an accident from occurring, and an accident still occur. But the question is, are you liable? Are you negligent in those situations? And I hope that answer is no. So then the last element here, damage, this is usually more of a defense. When we get to a point where we're talking about damages, this is a defense. So, yes, this person slipped and fell coming down the stairs, but those chiropractor bills that you're trying to stick to the church, those relate back to a previous injury. Or worse, those are actually bogus and they're just trying to get money from the church, which happens. We don't want to assume that, but sometimes it does happen. So your damages, a lot of times that's what's actually being litigated. You'll get to a point in litigation where everybody recognizes, yeah, we had a duty. Yeah, we breached it. We messed up. But listen, we're only willing to pay, $17,000 and you're asking for $17 million. That's a little unreasonable. That's a lot of times where these things are litigated. And then finally, cause. And again, causation is usually more of a defense. There's usually no question about whether a particular damage was caused by a defendant. The issue is how much of that causation can we assign to other people. So, for example, he fell and slipped, or he slipped and fell, but he was actually running down the stairs and using the handrails to slide down. Okay, you've got some negligence of your own there. That's not just all the church's fault. She slipped and fell, but she was wearing these ridiculously high-heeled shoes, and she was texting, walking down the stairs, wasn't using the handrail. Okay, you've got some of your own liability there. So many of these, this is what we call comparative negligence, where we take a look at the negligence of both parties and who's more at fault. And different states vary on how they go about addressing those issues. Some say that if you are less than 50% responsible, then you're not responsible at all. Some states say, well, you were 40% negligent here, so I'm only going to make you pay 40% of the damages. Kind of depends on what jurisdiction you're in, but that's how those are addressed. So the million-dollar question, how do you protect your church? And so here's what I would do as a result of this case, but also just in general negligence practices. First, have those policies that we've discussed. When I address a church, or I'm talking about having a policy or talking about bylaws or some other things, my goal is, I'm thinking like a litigator at that point, and all my time in litigation, I want to draft a document now that I can take to a judge in the future and say, listen, because we followed this policy and this was our policy and this was our belief, we need to be out of court quickly, quietly, and inexpensively. And that's my goal all the time. If a church gets sued and there's nothing I can do to stop that, I want to get that church out of court quickly, quietly, and inexpensively. So if you have these policies and these policies are followed, that can help. So have those policies as far as inclement weather and your hazard response policy. Second, get some surveillance cameras. All right, if you've got surveillance videos in your church, those can help you. And certainly we want those from a church security standpoint. We want to make sure that the people entering the building are not coming for nefarious intent or anything like that. So we need to have some security cameras in place for those reasons. But, a lot of times there is comparative negligence in these cases. The problem is we just don't have any proof of it. And so, the slip and fall may be somebody else's own fault. They're sliding down the handrails at the church, but they say they slipped and fell, or maybe they also slipped and fell and were running down the stairs. but we just don't have any proof that they were running down the stairs, and so all of that liability is now on the church, and we don't necessarily want that. So third, have an incident response form. This is a simple form you can get, and I can certainly provide that to you if you need it, but it's just a form that you're going to have witnesses fill out, or anybody who was actually hurt fill that out. Give me your name, your telephone number, your address. What did you see happen? Did you take any pictures? Are there any videos? Things like that, just so that you've got some documentation as to what happened. And again, that's for the purpose of going to the court and saying, here's the evidence that we've got. We want to make sure we document that well and get you out of court quickly, quietly, and inexpensively. And then finally, and we talked about this just briefly a minute ago, but train your volunteer teams how to respond to an incident like this, okay? I know people say, well, I only signed up to work in the nursery. Most people don't say that, but for people who are in the nursery, they may say, hey, this is enough. I understand that, but you need to be able to say, if there's a spill, we've got to address that. Heaven forbid somebody carrying a baby slips and falls, and now you've got not only a hurt mama, but a hurt baby as well, and somebody knew that spill was there but didn't sign up to clean up spills. They just signed up to work in the nursery, and that caused all sorts of problems. So we've got to be careful with that. Train your volunteer teams, have those volunteer teams working alongside and use that parallel between volunteer team and your hazard response policy. So now let's talk real briefly about property defects, because this is ultimately what this particular case hinged on. Was I said there was a property defect that you should have fixed before I slipped and fell. So these kind of cases are what give lawyers a bad name. I'm going to go ahead and throw that out there, because in some states, not all states, but in some states, these are the kind of laws that hold property owners liable for injuries to robbers when they break into your house and get hurt because of a property defect. And so in this case, here's what the issues are. First of all, the basic claims are still sound in negligence. So if, for example, do you have a duty to build stairs of equal height between steps? Some states would say yes. Some states would say, maybe not so much. It's really going to be dependent on your local building codes, but we'll talk about that some too here in a minute. Do you have a breach by failure to do those things, and so forth and so on. So it's very, very similar to a negligence case. These cases are really pretty easy to avoid, okay? If you'll just keep your building up to code. I know that can be expensive, and I say just keep your building up to code. That's tough. But if you keep your building up to code, that's going to avoid some of those things, because if your building is up to code, then you don't have a property defect that they can sue on. So you can do that. If you see wear and tear that could cause a hazard, obviously fix that wear and tear. If the carpet's coming up, fix that, because somebody could trip on the carpet. Whatever the case may be, if you can keep your facilities in relatively good repair, you should be fine. Now, let's talk just real briefly, though, about the three different types of people you can have in your building, and the types of type of duty, at least, that you owe to those three different types. So first, you've got your invitees, okay? And for the most part, churches have a lot of invitees. Every Sunday, we're going to be bringing in everybody who comes in the building, except for an employee, is going to be an invitee. We want people to come. And so landowners have to use reasonable and ordinary care to keep their property safe for their invitees. You've got to fix hazards that you know of. You've got to fix hazards that you should know of. Or at least you have to warn your congregants. If you can't get that hazard fixed, you've got to warn people about those hazards. And if you don't, you've breached a duty in this regard, as far as property hazard liability, and any damages that result from that could be your church's responsibility. But if you exercise reasonable care or you give adequate warning, you're not automatically liable. There's a misconception out there that says, listen, if I fall at somebody else's property, they're responsible. And that's just not necessarily the case. You don't have to guarantee somebody's safety. You do have to take reasonable and ordinary care to make sure that your facilities are safe. But if you do that and they fall anyway, that's not necessarily on your church. All right. Now, there's a lower duty that the churches offer to what's called a licensee. A licensee is somebody who you give permission to be there. You haven't necessarily invited them, but you've given them permission to come. So, for example, somebody who could be a licensee would be somebody like an IT professional who's coming in to work on your church's network infrastructure. Or it could be somebody who is, a licensed professional counselor who you bring in on a contract basis. Or if you need me to come see you and help you through something, I would be a licensee. I'm not invited there, but I'm given permission to be there. So you owe a lower duty to those licensees. That duty, if I can find out my notes here, is generally the rule is the same, but you just have to inform them of hidden hazards that you know or should know. know of. You don't necessarily have to fix it just for them, but you at least need to inform them that it's there. You need to warn them that it's there. And certainly you can't do anything while they're there to actively try and harm them or anything like that. That's a completely separate tort. So the lowest level of duty that you owe is to a trespasser most of the time. We're going to talk about that here in just a second as well. So if you know of a trespasser in your building and you know that there's a hazard, in some states, you do have a duty to inform them about that hazard, even if they're not supposed to be here. Now, the most common problem, and this is where churches can get into a lot of trouble, is with a trespasser under a doctrine known as attractive nuisance. Okay, if you have a pond on your church, you know what? There may be some kids who want to go swim in that pond in the summer, and what happens if they drown? Do you have a big parking lot? Some of you are probably dealing with the problem of people wanting to go and skateboard in your church's parking lot. That can cause a problem. Do you have playground equipment? Families and kids may want to go play on that playground equipment. And so this is all called attractive nuisance, and the common denominator is children. So let's talk through this just real briefly. Here's what the Restatement of Torts, it's a big legal treatise, says, very respected, but it says, a possessor of land is subject to liability for physical harm to children who trespass on their property caused by an artificial condition. So that's anything that's not naturally there, okay? So it could be a building, could be a parking lot, could be a playground, could be even a pond that you've built, a relief pond, whatever. If it's there, you can be liable for damage or injury to a child if that place or condition is one which you know or you have reason to know children are likely to trespass. So if you put playground equipment on your church, you should know that children are likely to trespass there and come play, all right? The second element is that condition has to be one which you know or you have reason to know and which you realize should realize involves an unreasonable risk of death or serious bodily harm. So if you have playground equipment, that playground equipment is 15 feet off the ground and kids climb on that stuff, you should know that they could fall and break an arm or have other serious physical injury. The children don't discover the condition or realize that there's a risk involved in participating in that activity. So because they're children, we're going to impute to them a lack of knowledge and a lack of judgment in how they interact with that particular hazard. The utility to you or your ability to maintain that or eliminate the hazard is low considering the risk that somebody could get hurt. And so if they have to prove that particular point, but if it costs very little money for you to remove it or to put a fence up or something else, some other safety equipment, and the risk is really high that somebody could get really hurt as the condition currently is, then you're going to be held liable for that damage. And finally, if the possessor fails to exercise reasonable care to eliminate that danger. So if you don't exercise reasonable care in taking care of that particular condition that might attract a child, you can be liable. So I'm going to do a whole lot on that particular case, but there's a lot there. There's a question here. Let me answer that one real quick. How do churches protect themselves from an attractive nuisance? And it's going to depend on the nuisance. And so, for example, the best way, and I'll say this, the best way to prevent against an attractive nuisance is a fence. Okay, so if you can fence off your playground equipment, if you don't want people from the public using that, I think that's a great thing. I know the church that I go to, we have a relief pond, and where all the water from the parking lot drains into this little pond, and then we are actually able to use that to irrigate the landscaping we've got at the church, and all that's great. But we've got that fenced off because we have noticed people want to go down there and fish, of all things. I don't know how fish got in there, but they want to go down there and fish, or they want to go swim in this little relief pond. And so we cordon that off. We just don't let people back there, and we tell them no trespassing, all that stuff. If they cross over that line anyway, that's on them. The hazard there is you can't fence off your entire parking lot most of the time. So you still may have people on the parking lot who want to come and do crazy kids who want to come in and do donuts in the parking lot, or they want to go skateboarding in your parking lot. And about the only thing you can do there is have a sign up that says don't do that. It's not like we want to be inhospitable members of the community as the church, but we do want to make sure that people understand if you're here, we could be held responsible for that. And so, no, if you're going to be here, no skateboarding on the church property. And so those are some things that you can do. If the second question here, if a church installs a playground, do we update our insurance? I would certainly say let your insurer know. that if you have a playground, your insurer needs to know that. There's certainly things that you can discuss with your insurance company, but certainly special, rider policies for things like that they might be able to cover. Typically, your general liability policy is going to cover that type of stuff. The question is, do you really want your general liability policy to have to pay those things if we can avoid doing that? Because as soon as they have to pay a claim, you're going to be in a position where your insurance rates may have to go up and so forth and so on. Or if you don't have sufficient coverage to pay a claim, that's an even bigger problem, because then they can come after you for the rest of it, unless you're in one of those oddball states where charitable immunity still exists. And I think there's only one or two of those. So hope that answers those questions. Let me move on just real quick. If there are any more questions, throw them up there. I'm glad to answer those. A couple of quick other cases. This next one is called Estate of Wagonhurst versus Friends of Peace Church. The facts here is the church had inadequate parking. This is another property issue, and they instructed their congregants to park across the street. And it was a busy street, and for years this had all happened, but the church was providing some safety personnel or some safety equipment, and they had that in place. Well, one night, a congregant was struck and killed crossing the street. The estate sued the church and for wrongful death. And that particular night, the only equipment that the church had up were reflective cones, kind of noting that this was a crosswalk. And so the estate sued the church and said, this is wrongful death. You were negligent in how you handled that. And so again, negligence case. What's the duty? The key point here is that if you assume a duty of any kind, you have that duty. All right. And so one of the factors that this particular case hinged on was another case that this particular court heard. This was out of the state of Pennsylvania. And in that case, the court said, listen, yes, this particular business, it was a restaurant, they didn't have adequate parking. And yes, people parked across the street, but the restaurant did not encourage them to park across the street and did not provide any kind of safety mechanism. And so when somebody crossed that busy street coming to the restaurant and got struck by a car and killed, the court said they're not responsible. What was different in this case is that the church encouraged people to park across the street, but then specifically that they undertook a duty by placing cones out there, by sometimes having volunteers in vests act as cross guards. By taking that duty, they then assumed and had that duty, and they had to exercise that duty in a manner that protected the people and the congregants of that church. So those facts were sufficient for this court to decide, you know what, you have assumed that duty, and now we need to go back to the circuit court or the lower court and determine whether or not you breached that duty, and we're going to do that through a trial. So whether that duty was breached is going to be up to the trial court, but first of all, the court left it open as to whether the church assumed an additional duty because it encouraged congregants to park on the other side of the street. And it's open to debate, but I'd advise churches in similar situations that they've assumed a duty at that point. If you encourage people to park in some particular place, you've assumed a duty to make sure that they're safe. Just as if you encourage them to park in your parking lot, you've got a duty to make sure that your grounds are reasonably free of clutter and slippery surfaces and so forth. So I think you've accepted a duty at that point. Another issue that the trial court left open is whether the use of traffic cones was sufficient to fulfill that duty. And again, it's open for argument, but I'm going to guess that the court's going to require more than just traffic cones under those circumstances, because those really, there's reflective cones there, but there are reflective cones on the side of the street for any number of reasons. It didn't necessarily designate that as pedestrian traffic. And so either way, this is a good example of a very fact-specific scenario. Okay, I can't tell you that just because people have to cross the street to get to the church that you're required to have some sort of safety precaution in place or how to provide that safety precaution. But because it's so case by case, you really need to have an attorney take a look at some of the operations that you've got going on in your church. So damage here, obviously, it's a wrongful death suit. The damages are going to be somewhat difficult because the deceased was in his 80s, but there'll still be some there for sure. And here, this is an example of the causation being an act of omission. They didn't do something. And so if they were found that they did not provide adequate safety precautions when they had assumed that duty, that omission is going to be the cause of the damages that were caused. So next case real quick, Pentecostal Church of God versus Douglas County. This is another property case, but this one is a little bit different. Here the church sought a special use permit for property that it purchased to build a church. The government then denied that permit, and the church sued. And so there were four issues that were brought up on appeal. One was abuse of discretion. The second was the Equal Protection Clause of the U.S. Constitution. The third was the Due Process Clause of the U.S. Constitution. We're only going to talk about one of the four issues that were brought up in that case, and that is RULIPA, or that's short, or RULIPA, depending on how you want to pronounce it, but that's short for the Religious Use of Land and Institutionalized Persons Act. So under that act, the government is prohibited from imposing a substantial burden on a church's religious exercise by way of land use regulation unless imposing that substantial burden furthers a very compelling government interest, and it is the least restrictive method of fulfilling that government interest. All right, this court only dealt with the substantial burden piece because it found that the zoning board's ruling did not impose a substantial burden, and it justified that decision based on, first of all, that there was no evidence before the court of less suitable sites, that there were no other sites in the area that they could build this church. There was no evidence that the church would be denied a permit on a different property if it so chose. There was no evidence before the board that the denial was based on some sort of religious, on a religious basis, which is obviously improper. There was no evidence of a really long delay in this process, that within 3 months, the application had been made, the board had ruled, and there had even been an internal appeal of that ruling. And so there was no really long delay here. There was no evidence of large financial loss, that they hadn't invested just tons of money in order to get this property up to snuff for church use. There'd been no evidence of prior denial of land use permits. Now, this is a case out of the Ninth Circuit. It's actually not a Ninth Circuit case. It was out of the state of Nevada. It was a Nevada federal district court. But within the Ninth Circuit, it's a little bit more of it's certainly the most liberal circuit court, circuit court of appeal in the United States. And so the restrictions there are much tighter than other parts of the country, which just says to me that the U.S. Supreme Court's going to have to pick up some of these cases and start weighing in on them. But how can you protect yourself, and how can you protect your church on this issue? First of all, if you're going to plant a church, which I encourage churches to take a look at, if you're going to plant a church, you need to start taking a look at some of the land, especially if you're going to use brick and mortar to do that. But here's some things you need to consider. You need to have an attorney help you in the process. Most of the time, this is done by realtors, it's done by title companies, it's done by engineers and architects, and your civil engineers, your contractors, construction folks. Most of the time, they're the only ones who are involved in this process, and that's okay. The problem is those guys are not necessarily trained on what evidence you're going to need on appeal. And so if you don't get the ruling you want, that's going to allow you to use that land for religious purposes, and you need to appeal that to a higher court, you may not have the evidence that you need. And had an attorney been, I don't know if an attorney was involved in this particular case early enough, but I think that attorney could have gone to the board with, here are 197 pieces of property that are for sale in this particular area, and none of them are sufficient. None of them will work for what we need to do for our church. You can certainly go to that planning commission with an affidavit from a realtor that says, hey, I've helped them find property, and none of the other properties on the market are going to meet their needs. That certainly helps. Keeping really detailed records of your conversations with officials, especially ones that indicate that they may deny a petition. Again, the court here took a look at everything and said there was never any conversation that they were thinking about approving it. There was no conversation about denying it. There's just no evidence before me that I can make a ruling on. And so you need to keep real detailed records of those conversations. You need to continually talk about this is religious use. Ultimately, the court threw in a whole lot of information and a whole lot of evidence that talked about, well, this is a residential area and there's traffic issues here. If you focus on the aspect that this is religious use, if you've got a hostile planning commission, the whole idea there is to make sure that they know it's religious use and kind of put them on notice that if you deny this, there's at least going to be some evidence that it may have been for religious purposes. So constantly talk about, we're going to use this for religious use. Object to any long delays. If they're constantly pushing you back, object. Put that objection in writing. Again, in this particular case, there was no evidence that there was a long delay, but even if there were, if they didn't object to it, they've probably not preserved that particular issue for an appeal. So make sure you object to any long delays, and then keep very, very detailed financial records. And this one actually surprised me a little bit, that the court would say, well, I don't see any evidence that there's just a huge financial loss here. Certainly they had spent money on attorneys by this point. They'd spent money on contractors and surveyors and a traffic study. And I mean, they had spent money, but there was just no evidence in the record for the court to review that would say, yes, there had been financial loss. And so make sure you're keeping those documentation. And so one more thing, before I open up the floor for any questions. We're not going to go over another case, but I did read a case, and the first sentence of that case just stuck out to me. And it's a kind of a sad statement, but here's the first sentence of a case that I read this month. It said this: the parties' long-running dispute involves, among other things, title to and possession of church property. Now, read between the lines there for just a second. This court is obviously tired of hearing this church and this diocese duke it out in court. So all that to say, if I'm sitting in the judge's shoes, or if I can impose if I can guess what that judge is thinking, that judge is really tired of hearing a church fight in court, and that's a sad state of affairs. It certainly doesn't do any good for the cause of Christ. And so we've got to do everything we can to stay out of court. And that's why I do this. 1 Corinthians 6 tells us to stay out of court as best we can. It's why we do this webinar. It's why I podcast here and there. It's why I throw all this stuff up on Facebook. And it's why all of this stuff is free. I try to provide as many resources as I can to as many churches as I can, because I want to see churches stay out of court. I want to make sure that what churches are doing are advancing the cause of Christ and not fighting in such a fashion that it harms the cause of Christ. And so that's why we're doing this stuff. These webinars, for all you guys out there, if there are any questions, go ahead and throw those in the chat window, or unmute yourself, raise your virtual hand. But for those of you still out there, these webinars are always going to be free for anyone who wants to participate. And there's so much more you can get. We're going to have forms in our client-only area that you can use. We're going to have samples of different documents you can use. We're continuing to develop those. That's going to be going live here within the next couple of weeks. We've got a group I call the Church General Counsel Solutions Group. You can join that group. It's a Google group. It costs $8.99 a month per person. Okay, so it's nothing. But when you ask a question in that group, I'm guaranteeing that you will get an answer from me or from an attorney that I hire to do that. And so you're going to get an answer from an attorney, but you may also get answers from other pastors from all over the country who have dealt with similar issues to what you're asking about. And so that's out there. It's a small group, but it's going to be growing, and we're continuing to advertise that and try to get people into it. We always have these individual ways of helping build individual components of your church's defense mechanism and defensive walls, from your foundational documents like your bylaws to your statements of faith and articles of incorporation, to your policies, to your contracts and anything like that that's going on, to your insurance policies. All those different things are means can be used to protect your church and help your church operate more efficiently. And so we've got different things that we can do in order to help you guys do that. And then if you wanted to retain me, you can certainly do that. And here's what I tell people. Listen, I don't charge hourly. There are a lot of attorneys out there who will help churches, and they will charge $150, $200, $250 an hour, and I just don't do that. All right, for the smallest churches out there, 500 or less, it's $1,000 for the entire year, and then I'm your attorney for whatever you need. Okay, the largest churches out there, more than 2,000 people, it's $2,500 a year, and again, I'm right there, and there are tiers in between that as well. So people tell me, and when I rolled this out to some business leaders in the area, I mean, I'm in Walmart's backyard. We've got Tyson, JB Hunt, 3 Fortune 500 companies within 5 miles of my little rural area here. But in talking with some of these business leaders, they said, "You're crazy. You've got to raise your price." And again, what I told them is, God did not call me out of ministry when I left the pastorate to start helping churches with legal work. And nobody ever entered the ministry to get rich. And so I'm not in this to make a lawyer's salary. I'm in this to help churches advance the cause of Christ. I want to get these churches secure. I want to help them operate more efficiently and operate in a legal manner. We're going to see cases again next month. We do this every month. So just be watching on Facebook and Twitter for the next sign up for the next Churches in Court webinar. But we're going to be talking about another 20 or 30 cases that I'm going to read over the next month in which more churches are in court. And it happens every month. And here's the sad part. There are churches in court every month. For the last 2 months, I haven't seen a single mosque. I haven't seen a single temple. Haven't seen a single synagogue. Haven't seen any other religious organization in court for the last 2 months. That's not always the case, but in the last 2 months, I have not seen those come through. So We're here to help churches, and if there's anything we can do to help you, reach out to us. Go to churchgeneralcounsel.com for more information. You can also find us on Facebook, find us on Twitter, find me on LinkedIn. Be happy to connect with you there. And if there's anything I can be doing to help you, please reach out to me. I'd love to help you secure your church. So if there are any questions, we'll take those now. Otherwise, we will be adjourned. I'll stick around as long as we need to.